Welcome again to my podcast, When Things Go Wrong with Paul Taylor. My name is Paul Taylor and I'm a licensed paralegal by the Law Society of Ontario. In this second episode of When Things Go Wrong with Home Renovation and Repairs, I would first like to start by stating that while I have represented many homeowners and contractors, I'm in no way labeling all contractors as bad, nor am I labeling all homeowners as bad either. There are many good reputable contractors and there are many good homeowners. In providing this information to you, it is my hope that it will help you find those good contractors. And if you're a contractor, find those good homeowners. While this episode focuses more on the side of homeowner, there are many points that contractors can use to avoid those few problematic clients who happen to be homeowners. I will be highlighting them throughout this podcast. I would like to first state that the information contained in this episode or any other episode is not legal advice and in no way constitutes any agreement for legal services. The information provided in this and all other episodes is strictly for informational purposes only. It is very important for you to know that the information I provide in the podcast or in the episodes of the podcast are in general terms only. Finally, that the information I provide is based on the laws of the province of Ontario, and that where you are, the laws may be vastly different than here in Ontario. This is why it is always best to get legal advice. In this episode, when I refer to civil court, I will be specifically referring to only matters being brought before the Ontario Superior Court of Justice, Small Claims Court specifically. For civil matters outside of a small claims court or outside of Ontario, you will need to seek the services of a lawyer in your area. In Ontario, the difference between Ontario Superior Court of Justice Civil and Ontario Superior Court of Justice Small Claims Court is that Small Claims Court can hear matters for monies claimed or for the return of property valued up to $50,000. That is as of October 1st, 2025. Previously, it was $35,000. This is referred to as the monetary jurisdiction of the court. Please note that monetary limits of small claims courts across Canada can vary greatly. For example, in Alberta presently, theirs is at $100,000, whereas at Newfoundland, it was, I believe, $5,000. So please check with your local small claims court to find out. It is also important to note that claims in small claims court can have a joint claim. This is where a claim has multiple plaintiffs, but where each plaintiff is entitled to an individual claim within that claim that is limited to claiming only the monetary limit of the small claims court. Again, I am only speaking to Ontario. So for example, if Bill and Mary both owned a house, they then hired a contractor who did work on their house, which was bad. They want to sue the contractor. They can both sue the contractor for a combined total amount of $100,000 in small claims court. As I mentioned, the limit increased to $50,000 per individual claim as of October 1st. Also, while a plaintiff can plead or have a claim over the monetary jurisdiction of the small claims court, the plaintiff can also choose what's called as waive any monetary monies over the jurisdictional limit. So, for example, Mohammed is making a claim against Bill. Mohammed is owed $56,000 and the current limit of small claims court is $50,000. Mohammed can choose to make a claim for the $50,000 part owed, plead the entire amount in his claim, but then waive the remaining monies over the jurisdictional limit of the court. But it's important to know that he cannot get the remaining money. He cannot sue in another small claims court case or go to Superior Court or anything. He's given up that right to that extra $6,000. You might ask, why would Mohammed do this? Give up the $6,000. The answer is simple. Small claims court is faster and much more simplified than the higher Superior Court. Not to mention, legal costs are considerably less. To hire, say, a paralegal in small claims court to go to a one-day trial can range anywhere from $2,000 to $6,000 to $10,000, depending on the complexity of the case. Whereas in civil court, to hire a lawyer, well, let's just say it's going to cost you a whole lot more. I wouldn't even fathom to guess the amount. Part of the problem too, when people ask me how much is it going to cost, is the complexity of the case determines the amount of time involved. So you may think your case is very straightforward and it's only going to cost $100. In reality, it could cost $5,000 or $10,000 or $15,000. It's really hard to know until, unfortunately, it's completed. For specific legal advice, you can always reach me through my website at www.paulsparalegal.ca, or you can send me an email to paul@paulsparalegal.ca. You can also call me anytime at 905-581-3602. It's an answering service, and you can leave a message anytime, 24 hours a day, 7 days a week. I've broken down today's topic, when things go wrong with home renovations and repairs, into two parts. The first part is to help you avoid when things go wrong with home renovation and repairs. In this part, I will be discussing about how you can prevent or reduce the legal risks when you, as the homeowner, need or want to have renovation or repair work done to your home. This part is also very important to those who are contractors. This is because I discuss important legal pitfalls for you to avoid. Whether you are a homeowner or a contractor, you will hopefully never need my services as a paralegal. However, if you do, my legal services do need my legal services. This is where the second part of this episode will help you reduce your legal risks as well in preparing to going to court. In this second part, I will discuss the steps you can take when things unfortunately do go wrong with your home renovation or repair project, or in the case of the contractor. Whether you are the homeowner or the contractor, as I say. The purpose is to help you prepare for an inevitable task of going to small claims court to attempt to get justice. In discussing the topic of prevention or reduction of the legal costs with the home renovations, I first want to discuss some important legal factors to be mindful of whenever you are hiring a contractor, or in the case of a contractor, when you're going to work for a homeowner. As a good contractor, you should always highlight these points to customers, and even go so far as making it part of your marketing plan to say that you're fully insured and you're covered by WSIB, and make sure you fully are insured and covered by WSIB. There's nothing worse than customers finding out you're just misleading them. A big thing of business is trust, and that is a big thing that will always get customers coming back. Some of the legal risks to consider when hiring a contractor is ensuring the individual or business is actually licensed to conduct business under that name. You would be shocked to learn how many people conduct business with individuals assuming they are a registered business when the business name doesn't even exist. It's not even real. In Ontario, the Business Name Act requires any individual or business who conducts business in Ontario using anything but their name or the business name, that it must be registered of the business they intend to operate in Ontario. So for example, my name is Paul, but I run my business, Paul's Paralegal. That is registered. But if Paul's Paralegal wanted to own another and run another business, then Paul's Paralegal would have to register that second business, just to be clear. So Paul's Paralegal couldn't run fake, or not fake, but other business names without registering them. The importance of this is to hold businesses accountable when they're dealing with the public. It is also important to know that if you're just running a business under just your name, say Paul Taylor, for example, you don't need to register this business name because it's just your name. The purpose of this law is to protect consumers against fly-by-night contractors. There's more to it, but in this part, that's what it's for. These are contractors that are in business under one name today, and then tomorrow they change the name and they're somewhere else tomorrow, hence fly-by-night contractors. When things go wrong, it makes it impossible to find these contractors and hold them accountable under the law because you just can't find them. In the show notes, I will provide you the website where you can verify the business you intend to do business with and has been registered either with the Ontario government or the government of Canada. It's the government of Ontario charges you $8 to do the business name search, but that $8 may very well save you tens of thousands of dollars. The government of Canada, it's a free search if it is a government name. So when you do the Ontario search, it may say refer to federal jurisdiction. Then you do the federal one because it's free anyway. You should ensure the business you intend to hire and the subcontractors they hire and use all have proper and adequate insurance. This can help you avoid major liability issues to you personally as a homeowner. Yes, I said to you, that's right, to you as the homeowner. Because if people walking by happen to be injured, they'll sue you and everyone. It's also important for homeowners to understand that insurance coverage on a contractor or repair person is not just limited to business liability insurance, but also workers' compensation coverage. That's Workplace Safety Insurance Board in Ontario, WSIB. Most homeowners are unaware that if you hire a contractor or repair person and they or one of their subcontractors are injured or killed on the work site, being your home, you can be held liable, financially liable. You can be sued by the family of the worker who's killed or by the worker who's injured, simply because they weren't covered under Ontario's workers' compensation system. This is why it is always important to make sure all workers who work on your home are insured by the WSIB. You can ask, and you have a right to know if the contractors working on your home can provide a clearance certificate from the WSIB. This certificate confirms they are covered by the WSIB. This is another selling point as a legitimate contractor. You let customers know you have a certificate from the WSIB and very willing to provide it to them. It's a selling point, believe it or not. You also need to do this with any subcontractors the business may use as well. I've also placed a link to the WSIB's website for you to check on a business yourself to see that they have a clearance certificate. Another liability risk as a homeowner you must be aware of is if the project fails to comply with the building code requirements, specifically by failing to obtain any building permits or to comply with the building code itself. This often occurs when a deck collapses or a fire is started from faulty electrical work. In every case, if there are no building permits, the homeowner is legally liable for any injuries in addition to any penalties imposed on them. Following building code requirements ensures any work done complies with industry safety standards and makes sure your home and your family is always safe. If you are unsure your project requires a building permit, contact the local building department and ask them. Never trust the word of a contractor to say, nah, you don't need one. Check yourself. A safe measure is that if you are changing any electrical, plumbing, or structure, meaning if you're moving electrical lines or moving plumbing lines, drains, water lines, whatever, or if you're moving structural support walls, then a building permit is likely required. But it's always best to check with the building department at your local city or municipality just to make sure. That one phone call may save you a world of trouble. Another point to preventing your renovation or repair project from becoming a nightmare is to have a written estimate. This gives you an ideal amount of what it's going to cost you for everything. That's included in the written estimate. Any extras outside of that are not included. There is a law, Consumer Protection Act, that limits anything over and above the estimate to be more than 10%, meaning if you're provided a written estimate of, say, $25,000, the most that the contractor can bill you more for is 10% more. Now, there are exceptions to that, unusual circumstances and events, and that would be stated in the contract. That's why it's always important to get a written contract. Signing the estimate is not legally a contract. It is merely you saying you are accepting their offer of work. Also, having a written contract with a contract and repairs in most cases don't require a contract. So if you hire an appliance guy to come in, they don't do a contract, but they'll just give you a written estimate and say this is what it is. Then when the work's done, you might sign the invoice or whatever to say the work is completed. If a contractor does not have or does not do contracts, you must insist or maybe not consider using them. A written contract states all the specific terms, will tend to avoid many legal nightmares when you may have to go to court. The written contract at a very minimum should provide, among other things, as exact as possible the scope of work to be done. Like, for example, the powder room bathroom in the house, remove the toilet, the flooring, the sink, remove the drywall. So it says all this. Dispose of debris. So the contractor is to dispose of the debris. Provide new toilet, say American Standard Model 1234. Provide new sink, American Standard Model 1234. So you know exactly when you're looking at this, exactly what you're getting. So if there was a dispute, he would look at this and go, I understand the terms, I don't know if I can do that right, terms, air quotes, of the contract. That is very important. I always joke with judges in cases like this when there's no written contract. And I say to them jokingly, this is the best part of your job, determining what the terms of the contract were. It is oftentimes not difficult to prove that two parties were in a contractual relationship because they're both saying it. Where it gets very complicated is what are the terms? And that is, what is the work to be done, what scope of it, what products or what materials are to be used, and even more importantly, an approximation of timeline of when each stage of the work is to be completed. Sometimes some contracts will provide a payment plan, like when 20% of the work is done, so much is paid, 30%, so on and so forth. If that's what you guys choose to do, that's fine, as long as it's stated in there. Never assume something is part of the scope of work. Make sure it is in there, in writing, in the contract, and clearly stated. Or don't do the contract, don't sign it. This way, there will hopefully never be any legal battles later, and you won't have any regrets. Also include diagrams for ease of understanding. If you're the homeowner, then insist on diagrams. At the very least, if you have to, go get your kid's crayon and paper and draw diagrams if necessary. At least this way, and attach it to the contract, and in the contract say, please see Schedule A, and write on the diagram Schedule A, whatever. And make the whole thing initial each page if you have to. Make it very clear and easily understand going into this project. You both understand what is expected of both of you, right? A payment schedule, like I said, can be helpful to understand as you progress. It is very, very risky to pay a contractor everything all up front. I have never heard of that. Oftentimes, contractors will need or require a deposit of work up front, meaning covering of the cost of materials. That way, if you just choose not to pay anything, they're not deep in the hole for the materials and their labor. So it's reasonable to pay an upfront deposit, and then, as I was saying, maybe a progression amount or something. Again, that's both what you both agreed to in a contract. Sometimes you will deal with, if you've ever had to buy a cell phone plan, you'll find they're what's called as forced contracts. You have no negotiation. It is what it is, take it or leave it. That's not typically what you'll have in these kind of contracts. You'll find that you can do some negotiating. And if they're unwilling and they're very, very adamant, some things, like if a contractor says, no, I'm adamant, you have to get a building permit, that's the way I'm going to do it. No, I'm adamant, I don't take cash. Those are good things. But if the contractor's doing bad things, saying, no, I'm not going to do this or that, you might want to consider walking away. Conversely, if your client, as a contractor, doesn't want a written contract, doesn't want to sign the estimate, and wants to do everything cash, you might want to reconsider it. You might think, well, it's work and I need the work. But then later down the road, you may end up paying more for that work than what you would have done had you not accepted the work, because they may come back and sue you. I've had this happen a few times, and the contractors regretted not doing a written contract. So I cannot emphasize that enough. Get it in writing. If during the project there are to be changes to the work, whether you want additional work or whether they have to do a working task for whatever reason, and both sides agree, then you can't just say, yeah, okay, no problem. You really have to either do an amendment to the contract or just write a new contract, put a date on it. That supersedes the old contract. So if everything is on computer now. So when you typed up the contract, you saved it. So then all you have to do is say, okay, well, we're going to change the American Standard toilet from 123 to 5678. It's a better model. This is what they agreed to, and it's an extra $100. Fine. You can easily do that. And it takes 2 minutes to make that change in the contract. The contractor can email it to the client. They can digitally sign it. The contractor can digitally sign it. They both have a copy. And that all took 2 minutes. There is no reason not to do that way. Or at the very minimum, and I'll explain later, is if the contractor is unwilling to do that and you're uncomfortable, or if the customer is unwilling to, send them an email and state, the changes. That way, at least it's in writing to some degree. It doesn't carry as much weight in court as a written change contract, but it might save you. For contractors, when you're doing written contracts, you should always have a clause to anticipate unforeseen issues. For example, probably the most famous one is COVID. During COVID, businesses had to shut down. That include construction companies. They were building these huge skyscrapers and they have very strict timelines. But one of the biggest nightmares in contract law was because COVID stepped in and everything stopped. I'm the so to speak customer of this. I'm the developer and you're the construction company, and you violated the contract because now the contract isn't finished. But it's not your fault. You had nothing to do with it. It's the government. So having these clauses in there protects you. Another example would be if a building inspector is delayed in inspecting, there's nothing you can do about it. You have no control over that. So if you put that in there, and if you're upfront and honest and you explain it to the customer, they should be understanding. As well as subcontractor delays, that you may have more control over. Like if you hire an electrician to come in and do the work and say he just doesn't show up. Okay, so now you're delayed a day. You say, fine, he's fired, I'll hire another guy. You can react to it quicker than you could a building inspector or something like a COVID shutdown. But put those things in there so the customer doesn't expect perfection. Make it very clear you're human. It's an imperfect process always, every time. No matter how long you've been doing it, whether 100 years or 100 days, you're going to run into problems. Another particularly crucial point is when hiring a contractor, oftentimes homeowners may have the contractors may have an amazing website, but then when you look closely, they have no physical address on the website. This is something I've always been very aware of as a consumer, and more so in law. The reason is that, and I'll tell you why, is because if you have a problem, you can't track them down. It's very hard. If that contractor is there in person with you, and you might have a cell phone and email, that's great. They can change both of those quickly. That's why it's important to have a physical address of a business address or the person's address. And the reason why is because when you go to sue them in small claims court, they have to be physically served with the papers. You can't normally serve somebody by email. There are exceptions, but it's better to have this than not. So there's no difference if you choose one contractor who has an address, everything's fine, great. It's stated on their invoice at the top, it has the address, phone number, everything. Over another contractor who has nothing, just their name. I would be very wary of them. Finally, when paying the contractor, never ever pay by cash. There is no reason to pay anybody by cash today. Always pay by check. Yeah, you can still pay by check. Checks are accepted. Credit card. Most contractors don't accept credit card because there is a fee and a cost. The banks love to charge us our interest fees and fees for business fees for processing. So many contractors are just like, no, I don't do that. If that's the case, then a bank wire, you can wire the money to them. They'll give you the banking information, or an e-transfer. Sometimes e-transfers are acceptable. The reason why I say to use one of those options is because this guarantees you providing you a copy of that transaction of payment. There is nothing worse than somebody saying to me, yeah, Paul, I paid him $5,000. How'd you pay him? Cash. Did you get a receipt? No. Do you have any proof? No. Ooh, well, we're going to have a hard time in court if he challenges that he didn't, you know what I mean, that you did pay him, right? So this is why paying cash is very, very bad. I would be very concerned if I'd be very concerned if a contractor or homeowner insists on being paid by cash or paying by cash. This usually is indicative of them not wanting to pay taxes. And I mean, I've heard this many times. Oh, just don't worry about the bills or anything. You know, we'll just pay cash. Try and avoid any responsibility with RevCan. And that's fine. I'm not here and I'm not enforcement for RevCan. But just remember this. It will put you in legal trouble with RevCan if it catches up to you. Whether you're the homeowner trying to get a good deal and RevCan gets wind of it somehow, say they audit the contractor and find out you're one of his customers and you never paid HST or whatever, they're going to charge you for the HST. You're going to have to pay it, not the contractor. You will. This is the same when employers are paying workers cash under the table. The employer then gets audited, and then the federal government, RevCan, the source deductions, or whoever it is, they come after, they find them, and then the employer gets nailed, but then the worker has to pay their portions to the government, CPP, EI, and taxes, right? You don't get a free ride because you supposedly didn't do anything wrong, even if you weren't party to it. The only difference is that they won't issue fines to you or anything like that. They'll just say, but you still have to pay this money because it is owed, right? So it's very important to avoid things like this, thinking you're going to get a better deal. So this is the end of part one, avoiding when things go wrong in that sense. In discussing the second part of this episode of when things go wrong, and most importantly, how to reduce your legal risk, I will now provide you some important tips to increasing your success in court if you have to go to court. First, and most importantly, if the renovation or repair project is not going as planned, probably one of the most important things you need to start to do right away, if you have not already, is to start collecting as much physical evidence as possible. This includes taking photos and videos of the progression of the work, any concerns. In fact, what I always suggest is before the project starts, you should take photos and video of it. You know, show the before. Also, too, is you can show your neighbors, family, and friends and say, this is what it looked before, this is what it looks like. I don't know. And today, there's no reason with cell phones. It's digital, so it doesn't cost you anything. With cell phones nowadays, there's no reason for you not to snap some pictures, as I said before, and even some videos, and after, and as you progress through. It is true what they say, a picture is worth 1,000 words, and a video is also worth 1,000,000 words. I would also add that while some people like to communicate with people by telephone or in person and don't like to do email or text or anything like that, that's fine. They're people persons, and that's fine. And they don't like to communicate by email. For legal reasons, an email has the sender, and I'll show you that. I don't know if you can see my pointer. You can see my name's there. That's the sender. 2, that's the receiver. And then for some reason over here, it has the date and time. And then it has the body of the message. So you can see everything. There's no question. When you use these messaging app programs, it's a picture of it. It just has just the body of the message. You don't know generally who it is. It might have just their name or something. And you don't know who it went to. You don't know when or what time. So you might say, well, no, that's fine. But now you're relying on your memory, and that could have happened maybe a year, 2 years ago. So good luck trying to remember all that. Use email. It's much easier. As you can see in this example here, the email, all the important information is there. Now, oftentimes you will need to speak to the contractor in person, and that is fine too. Again, the beauty of cell phones allows you with an app to record a conversation, whether by phone or in person. Yes, it is legal to record a conversation that you are party to, that you're one in the conversation. Another one of my clients, what they had is the video cameras outside and they just happen to have audio on it, and they recorded the whole conversation of the contractor, who had literally laid out the whole plan of the contract, but didn't actually give them a written contract. So this really helps his case when going to court, because now we can refer to that. Also, in situations where you are not able to record a conversation or communicate in writing, so in other words, you can't put it in writing what you want, an alternative is to just after the verbal conversation send an email to the party, or a letter if you're old school. And what you would say is, hi, this is so-and-so. I'm writing to confirm our conversation today, Monday, May 5th, whatever, at whatever time. And when we agreed to do this, or you agreed to do this, or I agreed to do this, that lays it out. Now, an email or a letter is not as strong as a signed contract or an amendment to the contract. But if the opposing side does not respond to the email, then generally speaking, the court will consider that opposing side never disputed it unless there is a strong convincing reason, being that there was already a written contract. So if there's no written contract, this helps. So if the contractor and you have to use them for whatever reason, you don't feel comfortable, send them an email and say, hey, Paul, just want to confirm you're going to renovate my bathroom for $10,000. This includes you doing and doing all this stuff. And then if I go back and say, yeah, that's right, well, there you go, awesome. If I don't respond, that's fine too. Now, but it's also important to say this is why during this process, both sides should monitor your email. And if you see something that you do not agree with, like an email like that where it says, hey, just want to confirm this, then you need to, don't ignore it. Some people go, I don't care, and just ignore it. Don't. Reply to it and say, hey, I never agreed to that. That way it makes it very clear in the future, later, you never agreed to that. Well, that is about it all for this episode of When Things Go Wrong with Home Renovation and Repairs. I really hope you enjoyed it. It was some very quick, short tips. It wasn't too long, hopefully about a half an hour, my video. So please don't forget to tune in to the next episode where hopefully I can speak better. And we'll be discussing the topic of when things go wrong with your customers not paying your bills, whether you are a contractor or a general business owner. In this next episode, I will be discussing the pros and cons of using collection agencies to try and get them to pay versus going to court first and using the power of the court to get paid. By this, I mean oftentimes people will use a collection agency, and that's great. But for example, I had a client where the company they allegedly owed money to hired a collection agency, reported to the credit bureau, so destroyed them, defamed them, slandered them, whatever you want to call it, and then they sued them in court. So basically, they don't even know if what they're saying is true. And that's the very definition of slander libel. Saying or writing something publicly that is not true or proven not to be true about this person, and then causes them harm. So when a creditor turns around and says, you're a deadbeat, you're not paying your bills, and then they publicly post it on Equifax or TransUnion or whatever, that hurts you because now you can't get the good credit rating, the good, well, you have a bad credit rating, you can't get the good interest rate, so now it costs you money. So that is a very, very viable lawsuit against the company. Now, if it is true, that's a different story. As they say in defamation law, the truth shall set you free. If what they're saying can be proven as true, then you don't have a case. So until next time, have a great day, and always be very careful when you're dealing with things in life, because the law does seem to creep into every part of our life. Have a great one.